obliquely speaking, with me, Tarun Namgia. Today, we continuing our series on what Chief Justice of India, Justice Dhananjay Chandrachud, said when he sent a strong message to the bar at large, where he said that I request members of the bar not to seek adjournments unless really necessary. He also noted that 3,688 adjournment slips were circulated in the month of September and October. And on the day he uttered these words, 178 adjournment slips were circulated. So he said it with a lot of concern. But we are taking up this issue because of two things. A, the CJI, no less, was forced to, in a sense, take up this issue. But secondly, investors who look at India as an investment destination also look at the time taken for enforcement of contracts, time taken for dispute resolution. And we'll get into this because whenever large disputes involving large amounts happen, even a day delay costs sometimes heavy amounts that have to be paid by the company with each day of delay to the banks. And it has a fallout effect and a ripple effect on the economy. But all this and more in the upcoming show. Let me welcome Neha Nagpal. She is a founding partner in NF Law Chambers. Good to see you, ma'am, and looking forward to some interesting insights. I have with me senior advocate Talwant Singh. He practices at the Supreme Court of India. In his earlier career, he has been a judge of the High Court, but now he's been practicing at the Supreme Court and other forums. Also, good to see you, sir. And looking forward to some interesting insights from you as usual. At the outset, let me request Neha Nagpal, founding partner of NM Law Chambers, in about the next 2 to 3 minutes, if you could share with us what the Chief Justice of India was trying to convey when he said these words.
So I think, Tarun, what Justice Chandrachud was trying to convey was actually encourage. I look at it two ways. One way I look at it is that he was trying to encourage more active participation and preparation from younger members of the bar as well. That look, just don't be so senior dependent. You also come forward if you can. Young designated counsels as well. Two, he was generally also trying to express the collective angst of judges, that literally they do sit up all night, burn the midnight oil, because in the Supreme Court on a Monday, Friday, you have 50 odd, on an average, every court has 50 matters. And then to have, sometimes letters circulated in the last minute for adjournments is very, it's wrong to even the bench. And three, what he was also trying to get at was, and this is the reason actually I call him the People's Chief Justice, is he was echoing a large sentiment of the common man. So I think he's expressed himself as not just a judge here, but also as a humanitarian and a very responsible citizen of the country.
Thanks for that opening comment. I'll go to senior advocate Talwant Singh. Sir, you've seen this from both sides. In your earlier career, when you were a judge, you know the issues of the bench. Now, as a practicing advocate at the Supreme Court, you know what problems lawyers face and what problems litigants face when you front face the client. Could you juxtapose your knowledge of this subject with what the Chief Justice of India, Justice Dhananjay Chandrachud, has said?
I think, Tarun, the anguish of Honorable Chief Justice is quite justified. Basically, what we see is that this is not the first time that he has taken up the issues which concern the Supreme Court the most, especially the Supreme Court's working. And whatever he says, he's not saying only for the Supreme Court. I think that has got its rippling effect in high courts and the district courts also. Adjournments have become a culture now.
Okay.
So, at the drop of the hat, the lawyers ask for adjournments. What I feel is that earlier, the adjournments were sought by the lawyers for some genuine causes. But now what is happening is that lawyers are more identifying themselves with the client. Even if the client has got some difficulty or client has got, had made some request to them, instead of saying that this is a difficulty faced by the client, they take upon themselves to ask for the adjournment. This is a very disturbing culture. This is what I feel. Because once their request has come from the lawyer, naturally the other side won't oppose. It's a personal reason of the lawyer. Because of my 37 years, you can say, in the profession as a lawyer, as a judge, and again as a lawyer, what I've seen is that at least one party is getting benefit of the adjournment. And in most of the cases, it will be the counsel of that party who will be asking for the adjournment. This is my initial take on
I want to ask you a quick follow-up question before I go to Neha. Suppose there is a big high-stake matter involving a couple of thousand crores. Now, it is not just that matter alone. Say 5,000 employees are part of that company, they get impacted because of delay. Banks to whom loan has to be paid get impacted if court judgments are responsible for the company getting some money. Thirdly, there is this element of the whole operation cost of the company. Whenever there is a delay in getting money, you have to bankroll the company via loans that you have to take. So your interest expense goes up. At such times, big lawyers or lawyers who charge high fees take an adjournment, go for some another matter because they have too many matters which they can't handle. This we see in Supreme Court time and again. Do you think that some correction has to be done by the bar also?
I think the responsibility has to be taken up by the senior members of the bar. Because as a human being, you can represent your clients in a limited number of courts. Now, it depends upon a person to person. One can fix a limit of 5, one can fix a limit of 10, one can fix a limit of 2, but that is not happening. I think I'm yet to see a senior counsel refusing a brief only on the ground that he has got enough on his table and he won't be able to justify and he won't be able to appear in a matter in Supreme Court once he is already there in Supreme Court. So once you take too many matters, you can't do justice to the court as well as to your own client. This is what I feel.
Point well taken. I also sometimes wonder if a lawyer takes an adjournment and then charges the client, what travesty will it be? That for my own cause, I take an adjournment and then bill the client. But that discussion is for another day.
There is a strategy for that. We will discuss it on some other day. How to take an adjournment and the client won't feel that the lawyer has taken an adjournment.
But yes, I'll go to Ma'am Neha Nagpal, founding partner of NM Law Chambers. Neha, one thing I want to know from you. Investors sitting in Europe, investors sitting in Australia, Canada, America, Japan, they all look at India as a very big and a serious market. But whenever they look at India as a market, there is a group of advisors who come up to these investors and show them how many days does it take in India to do a dispute resolution or enforce the contract. So for example, in India, a case from start to finish on an average will take about 4 years or 5 years. And for those 5 years, 2.5 years will be adjournments. In 2.5 years, maybe some case will be heard and the case will progress from the lower court to the highest court. Many times it is said that these investors may end up choosing or going to a smaller country, say a Vietnam or other countries which have picked up greatly because they think that there the justice delivery system may work faster. So today, this justice delay does not even impact just the legal system, lawyers or some litigants, but the whole investment climate, because an investor who gets a late judgment after 5 years and his money is stuck in courts in India will go to his home country and say, don't invest here, money gets stuck in India. Given that it is May, what do you think the Chief Justice is trying to convey? Is the Chief Justice trying to say that the whole growth of the country stops when lawyers take a simple adjournment? It's not a simple adjournment. The ramifications are multiple here.
So that's a very compounded question and a very, thought-provoking question at the same time. See, Tarun, I think one thing we have to give our judiciary is that it is a very robust judiciary, and sir would agree with me on that. Given our judge to population ratio, hats off to the Indian judiciary for the judgments that are delivered in a year. And I think we're obviously we are the most populous country in the world. And in comparison to that, the level at which justice is delivered is unparalleled in the world, in a manner of speaking, on sheer numbers of the population. But yes, I cannot run away from the fact, we as a system cannot run away from the fact that delays in dispensation of or disposal of matters does create prejudice at multiple levels. Why just investor sentiment? It also on personal liberty at times. And very many times one sees the Chief Justice, of course, and all other judges across various courts pushing lawyers to not just avoid adjournments, but also, listen, please give us fixed timelines. How long will you take? We want short written submissions. Everybody collectively is today working towards expeditious disposal of matters. NCLAT started this procedure that short written submissions of not more than 3 pages, to a point that the registry stopped accepting the 4th page of written submissions. Delhi High Court is avidly following the same thing now. Supreme Court has started doing it. So so what I'm trying to get at is we are cognizant as a system of the delays, the pendency. COVID did not help any. To some extent, it has, well, of course, it did help that we've all gone virtual now to a great extent, but it didn't help the delays. But I think the intention is to try and work around that. There are fast-track courts that are set up, there are lok adalats that are set up to reduce the burden. One cannot say that the judiciary is not cognizant of matters where there is a need for expeditious disposal, both on liberty matters and commercial matters. The Amazon, dispute was one such case where disposal did happen forthwith as it could be. Repeatedly, arbitration also, the law has been amended to make it very time specific. So I think the intent is there. It's also a function of how long will it take to really minimize things. Adjournments, while are becoming a problem, but at times you really can't avoid an adjournment also. You have a senior counsel who has been doing the matter from day dot. Now on day 10, if he's unavailable for personal reasons, for another matter, because he's stuck in another court, one can't avoid it. So I think one needs to really distinguish whether a adjournment is bona fide and absolutely required, vis-a-vis whether adjournment is just being taken to, football a matter so that one party continues with an interim stay and continues to gain, as opposed to, and therefore arm twisting the other party to come onto the table and negotiate. So I think that is a collective responsibility of the judiciary and also of us as lawyers.
Point well taken. I'll take this to Senior Advocate Talwant Singh. I want to understand from you one thing. When Justice Chandrachud said this, would he have in mind something like in commercial courts in India, sometimes it takes months together to get a notice issued. Now, if the money involved is a couple of 100 crores and the company is not that big, maybe the biggest lawyers of India can't appear for them. They are expensive for such companies. Other kind of lawyers do go, but if a notice is also not issued, do you think that somewhere the legal system can be held responsible for impacting investments? And what do you see as the solution?
Basically, when we came up with this idea of commercial courts, the government's purpose was to expedite the commercial litigation and keep it separate from the normal civil litigation, which takes time. But with the passage of time, of course, in Delhi, I think at district court level, we have devoted more than 42 courts only for commercial matters. And in High Court, I think all division benches are hearing commercial appeals, and all single judges, I think, are working on the commercial side also. The problem doesn't lie in the system. This is what I feel. The problem lies in the way we implement it. We have not given a special treatment to commercial cases. I think they get the same priority as other cases are getting. What is required at this stage is that, like we have taken family courts separate from the normal courts, similarly, we should have a separate system for commercial jurisdiction, right from the trial court up to Supreme Court. Those judges and those courts should not handle any other matter. But in Delhi High Court, you will find, since I was there, part of Delhi High Court for a long time, there you will find that the commercial appellate division is the same division bench is hearing civil matters, family matters, even criminal matters, and the same division bench is also the commercial appellate division. So somewhere, that priority is compromised. So my suggestion at this stage on the institutional level is that right from district court up to on the Honorable Supreme Court, we should have a separate parallel judicial system only for commercial disputes. First thing. Second, the lawyers should be more responsible. I think a time will come when a commercial dispute bar will emerge. They will be doing only commercial matters. They won't be involved in, personal liberty matters or maybe the civil matters, because there it takes time. And the timelines drawn in the act and the rules, they should be honored. I think there the role of judges comes in. Sometimes they also become lenient. And why a judge gives an adjournment, there is an interesting part to it. Sometimes the number of matters listed before him is such large that if he is going to entertain every matter, then I think he will not be able to finish his board. So a lawyer is happy seeking an adjournment. Suppose it's a dispute between a bank and a person who has taken loan from the bank. The person who has taken loan from the bank, he's always happy taking an adjournment because he is enjoying the loan at the cost of the bank or at the cost of the depositors. So similarly, suppose a judge has got 5 matters listed for evidence and every matter has got 3 witnesses. So no judge can record 15 witnesses in a day. So when we list the matters, as a judge, we list these matters, keeping in view out of these 5 matters, at least in 3 matters, there will be an adjournment request. So this culture has to, I think, go. The number of matters which are listed on a particular day for the purpose for which they are listed, that purpose should be fulfilled. Okay. And in case the lawyer is at fault or the party is at fault, the evidence, suppose it's listed for evidence, or you are not leading evidence for the last 2 dates, the judges should be bold enough to close the evidence. But the problem is, once you close the evidence, the affected party will go to the higher court. And after 1 year or 2 years, the matter is again remanded back with a cost of rupees 10,000 or 20,000. No. The principle of natural justice needs to be followed. Evidence should come on record. The court gave the opportunity to give the evidence. It is the party's fault that they have not brought the evidence. So this culture, I think, has to change. The timelines which are there in the act and the rules, they should be followed, not only by the judges, but by the lawyers and the parties too. Only then we will be able to have, expeditious disposal of commercial dispute. As you say, the country's reputation will grow up as an investment hub only once you have these timelines in place and a dedicated commercial litigation judiciary, as well as a commercial bar. This is what my suggestion.
One quick follow-up question before I go to Neha Nagpal. Will enforcement of arbitral awards also be a part of what you're suggesting, or should be a part of that commercial court system?
Yeah. It is part of the commercial litigation. Of course, it's a very much part of commercial litigation. Arbitration side timelines have been drawn, but they are seldom followed.
Yes.
This 1 year limit which is given for arbitrators to give award. Every second day you'll have, I think, a dozen of petitions listed before courts for extension of that period. So what is this going on? The parties are not serious, or the arbitrators are not serious. I think otherwise the arbitration will become another place for the people to delay the matters, for one reason or the other.
Point very well taken. I'll go to Neha Nagpal. Now, you do some of matters. Whenever a big businessman is bailed, they'll end up at your office and you're up to the court seeking bail for them. In these kind of matters, how do adjournments play out? What do you think the Chief Justice of India has done for liberty?
So, Tarun, I think it's most frustrating in personal liberty matters. I'm not undermining commercial matters. It's not that I don't do commercial matters. I mean, I do commercial matters. I'm doing a fair number of arbitrations. But I feel that somewhere the hurt is not personal there. It's because here there's so many emotions at play. There are parents, there are children, there are spouses, there is the person whose own life and liberty is in animated suspension, and every date has a lot of significance in their life. Like literally, they are living Tariq to Tariq till they don't get bail, and to have it adjourned is emotionally, mentally, financially very draining for them. And it gets worrisome when the client has medical issues, and sometimes they do have some serious and grave medical issues. So I think adjournment costs even in a commercial matter. It costs even in a personal liberty matter, and one has to be very responsible when we're seeking an adjournment. And and I do believe that somewhere liberty matters. And taking a cue from what Sir was saying, I think there need to be different benches that are hearing a criminal trial and hearing, maybe remand applications and bail applications, because that will then streamline things and help things move faster.
Okay, point well taken. I want to ask this question to Senior Advocate Talwan Singh. Sir, one thing I want to know from you. India is now a $3.3 trillion economy. We will go to about, in a natural progression, go to about $7-8 trillion in the coming years. Litigation will grow 6 times. Are we in a position to handle so much of litigation? 6 times commercial disputes will go up because economy is commercial disputes. So these will not be family cases. This will not be, or commercial disputes are just going to boom like anything. What should be done and what the Chief Justice is trying to say? Could you just give us an idea of what you feel of this?
Tarun, the problem is acute awareness. I think you look at the numbers even today. We have got 4 crore 45 lakh cases pending in district courts. We have got, I think, more than 60 to 70 lakhs pending cases in high courts. I think, and there are 3 high courts, I won't name them. If 50% of this pendency is only in 3 high courts.
3 high courts.
Yeah, and rest 21 courts, high court, they share the remaining 50%. And even Supreme Court, because of this COVID and all, the pendency has increased. We are unable to handle the number of cases which are pending as on date. If there is, let us say, if I go by a conservative estimate, not 6 times, even 2 times or 3 times more cases, we will not be able to handle them. The basic infrastructure, that is the number of judges, number of court complexes, staff, we have to increase that. First thing is that. Then we have to go for, the set timelines. I'll give you an example. The Consumer Act says that the dispute is to be decided in, I think, maybe 45 days or so. And the first notice, which is issued by a consumer commission or consumer tribunal, is beyond 90 days. So the total period for the solution or for the case to end has already been, taken for a toss. And then God knows it will take 2 years, 3 years, nobody knows. And that is the first step. Then you go to the appellate body and all those. The problem is that in India, nobody is satisfied with the decision of a court. This is another malady that we have. We have to, I think, even look at that. In other jurisdictions in foreign countries, once a judge has given a decision, people take it in the right side. But here, maybe because of the legal advice which they get, and the lawyer always knows whether his client is right or wrong. I am a votary of this school. It is the lawyer who knows. The party also knows. It is only the judge who doesn't know who is right, who is wrong. So the lawyer won't tell his client after losing a case at the trial stage, look, you were wrong, that's why you have lost the case. He says, no. We'll go to the higher court. This judge was unable to comprehend what I was arguing. So now I'll go to the appellate court. So from appellate court, then you go to SLP and all that. So the normal life of a case in this country is about 30 years. This is what I presume.
30?
Yes. Your case in the district court will take around 5 to 7 years. Okay.
10 years.
After that, once your matter is admitted in high court, okay, for right or wrong reasons, So, and it has once it been admitted, it will come on board after 10 to 12 years.
Correct.
And once your SLP is admitted, it is converted to criminal appeal or civil appeal, then another 10 to 12 years. Okay. And I'm talking about of the courts where the system still works. I'm not talking about the courts without naming them, where the murder appeals are being heard after 30 years. Can you believe this? In the High Court. Then one more step to the Supreme Court is left. 30 years. If a person has committed crime,
Somebody's languishing in jail.
Yeah, sometimes people are languishing in jail. And even if they are on bail, after 30 years, who is going to trace them? The police can't trace them. Whether they are in this world or not, nobody knows. Who was the counsel who was representing them 30 years ago? The counsel may or may not be alive. Or he may not even remember that an appeal filed by him is still on the board. So I think this situation is pathetic. Something has to be done. I think some changes are required in the system, the way we function.
The point very well taken. And because you said this point, I'll take this to Neha. You appear for a lot of businessmen who are in jail. Many you have advised to get bail. Many times we see businessmen languishing in jail for 4 or 5 years without conviction. When they have not been convicted, how they are to run their businesses when they are in jail, they can't run it. And is there a message here also that, even these things should be decided fast? Because why I say
a classic example of what you've said, very unfortunate, is in 2010, some of India's top businessmen spent 10 to 13 months in jail in the 2G trial. That was in 2010, when the charge sheets got filed. 21st December 2017, each and every accused was ba izzat bari. How do you compensate those 10 to 13 months of their lives? You can't. It's very unfortunate. Therefore, amongst the legal fraternity, at least very openly, everybody has started saying that the process is the punishment. I think that needs to change also, because we're looking at things where you can't turn criminal jurisprudence on its head, where you are guilty till proven innocent. We're innocent till proven guilty. And yes, adjournments and delays contribute to the process, which is the punishment. And then again, that comes back to the courts being overburdened. That again comes back to the judge to population ratio. What needs to be done is we really need to amp up our court systems. We need to amp up the number of judges. We need to also be open to going virtual more and more, because that will save time for a lot of things. There is Tareek pe Tareek sometimes happens because witness nahi aaya. Some lawyer is not in. So many times as lawyers, when we have to travel out of town, you end up taking an adjournment because you're in some personal difficulty, because you have to go for another matter out of town. But it's not that when you're out of town, you can't do a matter. If you can appear virtually, you can do the matter out of town and you can do this. So I think we need to let hybrid be a norm. That will ease the burden at a lot of levels.
And it's nice that when we see judges requesting or directing the juniors to argue when a senior doesn't turn up, at least it pushes the case forward.
Of course.
Now we will move to a round of final comments. Over to Senior Advocate Talwant Singh. What do you think the Chief Justice of India is doing, and what do you feel that he has done in the past 1 year since he's taken charge to push this disposal of cases?
I think every comment and every step the Honorable Chief Justice has taken, I think it is basically to remind the judiciary as well as the entire judicial system. Lawyers are part of the justice delivery system. That the way we are functioning, I think this is not the right way. We have to amend ways. We have to see that a litigant, a poor litigant, a prosperous litigant doesn't make any difference. Everybody has a right of audience. Everybody should be heard at the right time, and the cases should be disposed of in a time-bound manner. It should not be a Tareek pe Tareek, every time a case is listed only for the purpose of adjourning it. Adjourning a case is quite a burden for the court also. Your entire system is set in motion once a case is listed. And again, if it is, adjourned without there being a hearing, it is a great burden on the registry also. I think we have to think about those poor guys also who are working behind the scene to ensure that a case is there before the court, and it is ready for hearing. Judges also get frustrated because they come prepared, and in the morning you simply ask for an adjournment on XYZ ground. And sometimes the grounds given are quite, you can make it out that this ground just propped up at the last minute, and the lawyer is just putting it forward. We can, one can make it out. But of course, the principle of natural justice, everybody should be heard. I think we have expanded it a little too far. I think the time has come when everybody has to take a call. You have to do some introspection and see that people are putting their faith in the judiciary, and we should perform. The entire justice delivery system should perform to its best, so that the cases are decided in a time-bound manner.
Point very well taken. I'll go to Neha Nagpal, founding partner and Law Chambers, for a closing. What do you think the Chief Justice has done in the past 1 year through his utterances, both on bails, also now on adjournments?
So I think Justice Chandrachud really is, I said this before also, that he is really the people's Chief Justice. He is a humanitarian. He has constantly, in every judgment of his, in every conduct in court, always tried to resolve matters forthwith, tried to hold up fundamental rights of citizens, tried to lay down the law as clearly as possible. I'd like to share an incident here that happened where I was appearing in a matter. This is about 4 or 5 months ago. It was a bail of a really very unfortunate circumstances. This young man was the only male member in his family. His father had passed away. His sister was married, and mother had was in the last leg of cancer. He had moved an application in the concerned High Court saying that, look, the doctors have said my mother's in the last leg of cancer. I need bail. The High Court simply adjourned the matter and posted it for 2 weeks later. When he moved an urgency application saying the mother has passed away and I need to be released on bail for her last rites, that urgency application was kept for 2 days later. Literally, there was nobody to do her last rites. We, out of frustration, came against that order in SLP. The SLP was not even numbered, and I had mentioned it in Justice Chandrachud's court because back then the mentioning procedure was such that you could mention before the Chief Justice. He took up the matter on mentioning, said, you're in luck. The State Council is standing right here. It is 10:45. I will take this at 12:55 sharp. You confirm from the concerned jail if this is true, and I shall do the needful. At 12:55 sharp, he saw both of us standing. There was a matter going on. He said, I'll continue this after lunch. I have to pass orders here. The state confirmed. He released the person. I made a request on personal bond to the jailer so that he doesn't have to go running around. He said, very well taken. Thus the orders. He made sure that his court master uploaded the order and emailed it to the concerned jail by 1:20. And that man was released and could do his mother's last rites that day. So that is really, the way Justice Chandrachud has conducted his court. It's a very small incident, but it just tells of the compassion he holds as a judge.
Thanks for sharing that with now thousands of people who will watch this, promoters, GCs and businessmen will know, because people on this side, these things matter a lot to them. For many times for lawyers, it is another case. But for somebody who's going through it, that's his whole life for it. This was a good show, and a very good series that we did on what Justice Dhananjay Chandrachud says. We have a very vocal Chief Justice, and it is nice to know his mind on things. And one thing that we've realized here, that he tries to send messages right down to the district court, which then leads to some behavioral change, which is a very nice thing to do. It's a very good thing to have a vocal Chief Justice. I appreciate that Senior Advocate Talwant Singh, Neha Nagpal, founding partner, Venom Law Chambers, could make time. Thank you so much. This has been a very interesting discussion, and thank you viewers for joining us. Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.